Well, very good morning, everyone, and welcome to this webinar on personal data in a post-Brexit UK. We finally got to the end of the Brexit implementation period and come out the other side. My name is Malcolm Dowden. I'm a legal director in the data protection team here at WBD, and I'm joined this morning by Andrew Kimball, who's the partner and head of the data protection team. We're going to go through some of the features of the post-Brexit personal data protection landscape. And the focal point of our discussion is going to be really the practical steps that need to be considered over the next 6 to 7 months to make sure that the transition at organizational level is as smooth and effective as it can possibly be. You'll see on your screens that we have in the right-hand column a panel that should have Q&A as one of the elements of it. If you click on the arrow that is probably currently facing sideways next to Q&A, that'll open up the panel into which you can type questions as we go along. And my suggestion is that if you have any questions, do please submit them while the webinar is in process, and I will monitor them, and as and when we get an opportunity, I'll either pick them up or relay them to Andy for discussion. Any that I don't get to during the session itself, I'll be reviewing afterwards, and we'll then pull out a document that addresses any of the themes that emerge from your questions, and that pulls together some of the practical tips that we'll be discussing during the session. So do please feel free to participate. Now, Brexit, as you know, has finally got beyond the end of the implementation period. The implementation period ended at 11 p.m. on New Year's Eve, which was midnight in Brussels, just as we made the transition to 1st of January 2021. And for our purposes, one of the key consequences of coming to the end of that implementation period is that we now live in a world of UK GDPR as a separate, albeit very similar regime to the European Union's GDPR. They are formally fully separate parallel regimes. Now, that means that the UK is now treated as a third country from an EU and European Economic Area perspective. And as we made the transition into this brave new world, we did so in a circumstance where there is no adequacy decision yet in place made by the European Union, by the European Commission, in favour of the UK. Now, in the lead up to the Brexit end date, that looked like an area of substantial risk. Among all of the fears that related to a no-deal Brexit was the significant concern that a no-deal outcome might have interrupted or obstructed the flow of personal data, particularly personal data from the European Union into the UK. As well as the deal that was approved by Parliament on the 30th of December, there are a number of arrangements that run alongside the main treaty. And one of those is evidence that we've had some grown-ups in the room when it comes to data transfers and personal data protection. There is no adequacy decision as yet, but that process is underway. And to cover the gap, we have an agreed grace period of up to 6 months. It commenced on the 1st of January 2021, and during that grace period, transfers of personal data from the EU to the UK are permitted to continue without, at this stage at least, requiring additional safeguards. Now, there has been quite a lot of background debate as to whether the EU will reach an adequacy decision in favour of the UK. The commercial importance of personal data flows means that it would be a very significant step to withhold an adequacy agreement. But, as we've previously seen, the European Union and the European Court in particular has previously shown itself willing to intervene if it considers that adequate levels of protection for personal data subjects is not being afforded by a particular jurisdiction. Just think back to summer of 2020 when the European Court struck down the EU-US Privacy Shield arrangement. And they did so because of concerns over bulk electronic surveillance by the US federal government. Now, in the context of the UK adequacy decision, there have been concerns that the use of general warrants by law enforcement and intelligence services under the Investigatory Powers Act looked uncomfortably like that bulk surveillance regime in the US. And that was feared to be a potential barrier to the making of an adequacy decision. On Friday of last week, the High Court issued its decision, its ruling in Privacy International and Investigatory Powers Tribunal, giving you the citation on the slide. And that has removed the ability of those law enforcement and intelligence services to use general warrants. That, we think, goes quite a way towards removing a potential barrier to an adequacy decision being made in the UK's favour. Now, the detail of the grace period is crucial. It is a grace period of up to 6 months, but it falls into two parts. Initially, we have a period of 4 months, commencing on 1st of January 2021, with the possibility of an extension for a further 2 months if no adequacy decision is in place by the end of the initial 4-month period. So we have an outer limit for the process. It's also possible that the grace period might simply fall away and be terminated early if the European Commission accelerates its making of an adequacy decision. But for our practical purposes, we're looking at a period of 6 months during which there is no immediate need to change, but during which we do need to keep a very close eye on the progress of those adequacy decision discussions. Bear in mind that the Information Commissioner's Office, the ICO, has explicitly acknowledged the possibility that there might be no adequacy decision at the end of that period, whether it's 4 months or an extended period of 6 months. And the ICO has recommended preparation for that event. Now, we are reluctant to recommend spending money or incurring management time or opportunity cost in doing too much too soon to prepare for that possible eventuality, that contingency. So I'm going to turn to Andy Kimball and ask, what do you think, Andy, the grace period means in practice? What should we be looking at over the next few months?
So I think for me, the starting point is that organisations do need to consider preparing for a no adequacy decision. I think there have been a number of comments on the Q&A around, do we think there's a realistic prospect of the EU declaring anything other than adequacy? I think the direction of travel is towards adequacy, but organisations do need to prepare for no adequacy. And there are steps that can be taken now which will be relevant whether or not an adequacy decision is reached. And the primary issue, I think, for a lot of organisations is actually data mapping and understanding what data transfers are taking place, both EU to UK, but also UK to EU and elsewhere, as we'll come on to. I think organisations should consider putting in place alternative mechanisms. We'll come on to the issues around standard contractual clauses. As most will be aware, there are some new standard contractual clauses which have been issued in draft by the Commission, but timing is going to be a problem there because no decision has yet been adopted around those new standard contractual clauses. Malcolm, as you mentioned, I think organisations will want to avoid the expense of carrying out a repapering exercise to put in place sort of old standard contractual clauses, then only having to revisit that within a couple of months to put in place new standard contractual clauses. So there is an issue for organisations, I think, around whether they wish to take a more risk-based approach, perhaps looking at the more high-risk transfers, the more business-critical transfers that are taking place, looking at putting in place measures in relation to those transfers and leave some of the lower-risk transfers to a later date when there may be more certainty around what the position is. But I think it all comes back to, for organisations, having good data mapping in place to understand what the risks are across the organisation.
Yeah, I mean, we'll revisit the point of data mapping and the importance of that exercise, whatever the outcome of the discussions. I think over the next couple of months, certainly what we're proposing to do is to keep as close an eye as possible on the flow and the outcome of the discussions that are working towards an adequacy decision. And I think it makes sense to put down some markers within that initial 4-month period, just as checkpoints, so mid-February into mid to late March, just to make sure that the issue is kept in view as the sort of political level discussions develop. Because I think that from experience of previous discussions, you do tend to get quite a strong sense, in particular from the Commission, if things are moving towards an adequacy decision. So diarising those dates, I think, is going to be probably the most useful approach at this stage. Having looked at the shape and the detail of that grace period, I want to pick up on the point you made, Andy, about standard contractual clauses, the Sccs. And this, I think, is really important from a practical management and repapering perspective. We have what I'll refer to as the old set of standard contractual clauses. And these were essentially the legacy set from pre-GDPR days that were carried over in 2018. And we've known for a considerable time that there are shortcomings and difficulties with those Sccs. In particular, there is not a set of existing standard contractual clauses to cover transfers of personal data from EU processor to UK controller. The new set of standard contract clauses fill that gap, but as you mentioned, they remain to be formally approved by the EU. Consultation on the draft closed in December, and I mean the indications that I've picked up over the break are that there doesn't appear to be any showstoppers in the responses to that consultation, but we still don't have a firm date for approval. Now, that I think gives us a real benefit to be derived from the grace period, that we don't need to be racing to adopt SCCs as an additional measure for EU/EEA to UK transfers of personal data, but as we'll discuss, there are other factors if you're transferring data elsewhere in the world. So it's worth having a quick look at the key features of the new SCCs. First point to emphasize is that they're written in a modular way. They've taken a modular approach covering the 4 broad scenarios that I've listed on the slide. And they've also included a docking clause, which essentially allows a third party to join or accede to the SCCs at a later date. And that's very much geared towards streamlining and easing the process of repapering your arrangements or adding parties to your arrangements as your data transfer mechanisms evolve. So I think the new SCCs are going to be more easily workable, more usable, and without that critical gap. But we don't recommend racing to adopt them. Even when the new SCCs are formally approved, we have another grace period. And this time it's a grace period of 1 year from the date of formal adoption. And within that period, it's going to be necessary to implement the new SCCs. Now, that period is an outer limit. It's really important to emphasize that there could well be triggers within that 1 year period that would essentially require accelerated implementation of the new SCCs. So if you enter into new arrangements during that 1 year period, then you'll need to be adopting and implementing the SCCs as they're newly approved, or if you vary existing arrangements. So given the need to approach this in as orderly and as cost-effective a way as possible, I think what we're recommending is that if you have any programs of review of contractual arrangements or of contract precedents, that you build the SCC element into those planned maintenance or planned development processes. So only if you're entering into brand new arrangements, if you're processing on a different basis or with different parties, that you're likely to encounter a more ad hoc need to adopt the new SCCs. But all of this comes back to data mapping. And to understand where and when you need to implement the new SCCs, it's important to understand your data flows from the UK, both to the EEA and elsewhere in the world, so that we can determine which modules you need to use once formal adoption has taken place. So plan ahead and build this set of SCCs into your contractual management process for the year. Andy, anything further on that?
I would just add, I think, that organisations should look at the modules carefully, particularly given if you take, for example, the controller to processor module, that includes what I would call sort of standard processor terms as required by Article 28 of the GDPR. But those terms may well be more restrictive or differ than the terms you already have in place with existing suppliers and vendors. So I think there is an issue around comparing what the modules say with what you already have in place, because in terms of adopting the new standard contractual clauses, they will clearly take precedence over existing Article 28 terms. So there is some consideration that needs to be given to how you're going to deal with implementing the new standard contractual clauses and how they will map against what you already have in place from an Article 28 compliance perspective. And that, for example, will impact on issues around sub-processing and other arrangements. So I think spending time now looking, particularly when they're adopted, looking at what those modules actually say, and then thinking about what changes do we need to make to existing contract arrangements.
Yeah, absolutely. Just picking up a couple of the questions that are beginning to come through. The first question, just to nail a point, will the existing old SCCs need to be replaced within the 1-year grace period if there are no variations?
No.
Yeah.
Is the simple answer to that, but bear in mind that any remediation exercise can take a significant amount of time to put in place. Our experience for those who've been through the process for GDPR contract remediation, for some organisations they're still dealing with the tail end of that process, so don't underestimate the exercise required if you've got multiple data transfers taking place. I think there's a similar question actually around further remediation exercise. I think my view is organisations do need to consider that in terms of the data transfer side, and also looking again at the Article 28 requirements. Now's probably not a bad time to refresh some of the compliance measures that were put in place at the time GDPR was implemented.
Absolutely. And just to pick up another question, so the question is, what should we be using right now to cover transfers of data outside the EEA if the old SCCs are no longer valid and the new SCCs are still under review? It's the first point to make there is not quite true to say that the old SCCs are no longer valid. It is true to say that they are essentially on the way out. But Andy, do you have any comments?
Yeah, I mean, I think you would need to use the existing old standard contractual clauses if that's the mechanism you're using for data transfers until the new standard contractual clauses are adopted.
Yeah, the formal adoption stage is crucial for being able to point to the SCCs that you are using as essentially the legitimizing fact for your cross-border transfers.
The other point probably just to pick up around that, and we'll come on to it, is using the standard contractual clauses alone is not sufficient post the Schrems II decision, and we'll come back to that in the presentation shortly.
We absolutely will. On to the next issue, and we can pick up the SCC question under the banner of Schrems a bit later, but I also wanted to draw your attention to the impact of this split of GDPR and UK GDPR when we're looking at overseas organisations, so organisations that are outside the EU, EEA, and separately UK. And it's always essential to remember that both EU GDPR and UK GDPR have significant extraterritorial reach. That stems from Article 3. And Article 3.1 establishes the establishment test. In other words, if an organisation has either physical premises or operations or stable contractual arrangements within the EU/EEA or the UK, then they will be directly subject to EU GDPR or, as appropriate, UK GDPR based on that establishment. If they don't have premises or stable contractual arrangements, but nonetheless meet the targeting test, that is, offering goods or services to data subjects or monitoring the behavior of data subjects within the EU, EEA, or the UK, then GDPR applies in its extraterritorial form. And where Article 3.2 applies, the overseas organisation that has met the targeting test must appoint an Article 27 representative. Now, post-Brexit, the practical point here is that it might well be necessary to appoint a separate Article 27 representative, one for the EU EEA and a separate representative for the UK. The reason for that is that the Article 27 representative is the local point both of contact and enforcement for the respective regimes. So we need to have representatives in the right jurisdictions. And it's always worth mentioning that failure to appoint an Article 27 representative is itself a breach, subject under GDPR to a fine of up to 10 million or 2% of global annual turnover. It's one of those easy to miss but easy to fix breaches. There are some factors that we do need to flag, though, with Article 27 representatives, and that is the question of liability and suitability. An Article 27 representative has direct liability under specified parts of both EU and UK GDPR. In particular, the Article 27 representative is directly responsible for the Article 30 records of processing activities. They're also specifically called out as directly responsible for provision of any information that the regulator, the supervisory authority, legitimately demands. Those are the only areas where Article 27 representatives are specifically called out as liable. But there is a much broader debate about what it means for the Article 27 representative to be not just the point of contact, but also the point of enforcement for supervisory authorities within the EU or the UK. So when selecting, or indeed when deciding whether to provide Article 27 representative services, we need to think about those liability issues, and we need to think about the substance, the worth, the value of the covenant of the Article 27 representative. Andy, what would you say are the practical considerations that we need to have in mind when we're following that inquiry?
So I think, in my experience, due diligence is key. And I think one of the questions we've had is there a list of accredited EU representatives for UK companies? Not that I'm aware of, I think is the answer to that. I think you need to carry out due diligence on any organisation you appoint as a representative. They are not just a post box. They have direct responsibilities. You have liabilities through their activities because you are directly responsible as well for their activities as your representative. So other issues to think about are contract terms with your representative. What is the position around what the scope of their services is, and what is their position around liability and responsibility for the services they're providing. Also think about service levels with representatives, given the criticality of timescales from a GDPR compliance perspective. Ensuring that your representative is subject to appropriate SLAs is also important.
Absolutely. A couple of specific questions in relation to Article 27 reps. First question, can an Article 27 rep be a team of people, or does it have to be an individual? So can it be an organisation?
So it can be an organisation or an individual. Often they're organisations who then use a team to provide the services.
Absolutely. Now, the other question I think is really worth picking up here is in relation to territorial remit. Do you agree that a non-EU company collecting cookies is sufficient to trigger GDPR obligations? In other words, I guess tracking cookies, would that, in your view, fall into the monitoring behaviour element of Article 3.2?
I think you'd need to consider it on the particular circumstances, but in theory, yes.
Yeah, I think there's quite a lot of discussion about the particular nature of the cookies and what they're doing.
Yeah.
As well, so, I mean, one example is anything that's driving targeted ads, so that you get locally relevant content, is certainly something that I would flag as something that would need further investigation in that context. The point, I guess, is that the targeting test is purposely widely drawn. So it is the offering of goods or services, whether or not for payment. It is the monitoring of behavior, which can involve anything like tracking location. It can involve tracking of usage patterns on a website. So Article 3.2 is an easy thing to run into. Another question in relation to Article 27. Article 3.2 talks about data subjects. Does that include corporate clients?
I'm not quite sure what that question is driving at.
Yeah, and I think if we're talking about sort of corporate clients, that the question is, are data subjects, are corporate entities likely to be capable of being data subjects?
Yeah, so the corporate entity itself, not individual employees within a corporate entity, yes.
Absolutely. So we're always looking for personal data relating to living individuals, and that can crop up in what looks like corporate documentation or data. Yeah. If you have, for example, individual directors or other living individuals mentioned or capable of being identified by putting data together. Okay, so Article 27 representative, just to wrap up the critical point, it is now quite possibly going to be necessary for overseas organisations to have separate representation in the UK on the one hand and within the EU on the other. And just a supplemental point on the EU representative, it's necessary when you're talking about the jurisdiction within the EU, where you're going to appoint an Article 27 rep, for there to be data subjects in that jurisdiction. That can be quite tricky if you've got an overseas entity that is caught by, for example, something like a tourism site or a leisure sector site that inherently involves people moving around. So meeting the test of having a relevant EU jurisdiction is something that requires attention on a case-by-case basis. Andy, anything more on Article 27 before I move on?
Not for me.
Okay. Moving on to a different and quite odd aspect of this whole post-Brexit picture. The question of data subject rights. Is there a risk of double enforcement? Is there a risk that organisations are going to have to keep a close eye on both EU GDPR and UK GDPR? They're separate legal regimes, but I would argue that there are circumstances where both might apply to personal data processing. It's either carried out within relevant jurisdictions. So if you have controller to processor relationships that span UK and EU EEA, then you may well be caught by both regimes as a consequence of the location in which processing is carried out and the location of data subjects. You might also find that processing is caught by the extraterritorial provisions of each regime. But also, within the withdrawal agreement, we have this odd scenario that requires us to look at the date when data was gathered. So where UK organisations process, it's referred to as overseas personal data, gathered before the end of the transition period, we have specific provision that says GDPR, EU GDPR, applies to the processing of that overseas data. My reading of that provision has always been that it's something of a political lever against the UK, essentially providing a fallback application of GDPR if there is no adequacy decision in favour of the UK. It essentially provides residual access to and enforcement powers to EU GDPR supervisory authorities. What it requires us to do in relation to data sets is to identify overseas data acquired before 1st of January, so that is on or before 31st of December 2020, and to treat that legacy data as subject to EU GDPR as it stood on 31st of December 2020. And that's referred to as the frozen GDPR, presumably because they couldn't let it go. Andy, any other comments on this odd provision?
No, I don't think so. I find it odd in the sense that when we're talking about GDPR generally, we don't talk about where an individual is located. It's where the organisation that is processing the data is located. But it's just an additional challenge for organisations to be able to identify what data that may come within this provision is in existence as at 31st of December.
Yeah, absolutely. I mean, it's a strange one, isn't it, that this actually falls away in any event if an adequacy decision is made in favour of the UK. From that point, we're then back to the within jurisdiction test or the Article 3 extraterritorial test. This date-based and location-based test falls away. So just to nail that point, data collected after 31st of December 2020 needs to comply with UK GDPR. So the practice point that comes from the ICO is that we do need to carry out, as part of that data mapping exercise that we mentioned earlier, the date on which data was initially collected, it was gathered. An area of weirdness in this is that the definition of processing under Article 4 of each of these regimes essentially is a moving definition. It includes storage. It includes any sort of access or manipulation of data. So I think that we are in a position where it is quite possible for EU regulatory authorities and the UK ICO to assert jurisdiction in relation to any breach that happens over the next while. And on my reading of it, there is nothing yet that bars either EU regulators or the ICO regulators from enforcement. It is not similar to the lead supervisory authority position that applies within EU GDPR. So this element of complexity, I think, is a very compelling reason for wanting to see the adequacy decision accelerated as fast as possible. Now, we have one more area to highlight for you, and then I'm going to loop back and have a look through some of the questions that are coming in. But this picks up on the point that Andy made earlier in the session. So what about transfers or onward transfers to non-EU EEA countries? And this is where we pick up the Schrems II ruling again. So the first thing that the Schrems II ruling did, the headline point, was that it struck down the EU-US Privacy Shield arrangement. And that, as I mentioned, reflected concerns over US federal government bulk surveillance. Since then, since the July ruling, other jurisdictions have essentially followed the lead of the European Court of Justice. So, for example, data law regulators in the Middle East, including Abu Dhabi Global Market, have similarly concluded that data transfers to the US on the basis of a Privacy Shield type arrangement can no longer go ahead. So that's a big issue that needs to be sorted out over, I presume, the coming year or so. But Schrems also had a second strand, and it's that second strand we need to focus on. While striking down Privacy Shield as a mechanism for transfers of personal data to the US, the ruling did confirm that the standard contract clauses are potentially usable as a mechanism for legitimizing those transfers. And that is broader than EU to US. That element of Schrems II applies to data transfers anywhere in the world, to jurisdictions that are not covered from an EU GDPR or UK GDPR perspective by an adequacy decision. If you're transferring data to a jurisdiction that is not considered adequate, we need additional safeguards, which can potentially take the form of the SCCs. But SCCs alone are not enough. Depending on the level of protection afforded by the receiving jurisdiction, it might be necessary to add either contractual or technical measures to cover, to legitimize those data transfers and to protect the rights and interests of data subjects. So, Andy, what does this mean in practice for organizations? What steps and what thought processes do we need to be going through when we're looking at these broader international transfers?
So I think the first thing I would say is it's challenging in terms of the steps that organisations have to take. The European Data Protection Board has issued some recommendations in draft form for consultation, which came out in November. I think the consultation period has now ended. But that recommendation document includes a kind of a 6-step process for considering data transfers. I think within the time we have, the 2 key areas I wanted to focus on were, firstly, the transfer risk assessment, which is about considering the legal position in the country to which you're transferring the data. So what laws apply to the particular transfer, what disclosure access needs to be given to public authorities, law enforcement agencies in that jurisdiction, and what powers does the public authority have in that jurisdiction to access data in terms of surveillance powers and similar. So there is a piece around carrying out transfer risk assessments and practically how do organisations do that without spending lots of money either with lawyers or others to prepare those transfer risk assessments. But let's assume for the moment, and we'll come back to transfer risk assessments, let's assume the jurisdiction does not have adequate legal measures equivalent to EU measures. Then you're looking at what additional measures, next step, what additional measures, protections can you put in place in relation to those transfers? And the European Data Protection Board recommendations talks about 3 areas: technical, contractual, and organisational measures. But when you read the recommendations, the focus is very much on the technical measures. The contractual and organisational are almost seen as supplemental measures. And the technical measures, really, the key measures are encryption and pseudonymization. But for both those measures, there are sort of caveats. So one, it has to be strong levels of encryption. In relation to encryption keys, they need to be held by the exporter or another trusted organisation within the EU or another adequate jurisdiction. And similarly for pseudonymization, in terms of the mapping data, so that which links the personal identifiers to the pseudonymized data, the mapping data needs to be held within the EU or adequate jurisdiction. So there are caveats even in relation to encryption and pseudonymization. I would also say, in terms of the contractual measures, clearly it's worth looking at what additional measures you can put in place from a contract perspective, and that could be around requiring, for example, your supplier or vendor to give you transparency around what laws apply and how those may conflict with the terms of the standard contractual clauses, giving you adequate notice to the extent they're able to around access requests by law enforcement agencies. But the recommendations are very clear that these measures are limited from a contractual perspective because, of course, they don't bind the public authorities who will be accessing or obtaining the data in the recipient jurisdiction. The other thing I would probably say around the recommendations is that they give some use cases which are worth looking at in terms of working through those. And I think there are a couple in particular. Use case 6, which is around using a processor, third party in another jurisdiction to process data on your behalf, where the data is in clear or unencrypted form, where it appears to be saying that effectively if in that jurisdiction, based on your transfer risk assessment, the legal position is that the public authority has powers which go beyond that which is reasonable and proportionate, then they, in the draft recommendations, say that they're struggling to see what additional measures could be put in place to make the transfer meet the Schrems II requirements. Now, the challenge with that is, for a lot of processing activity, there is a need to be able to view and use data in clear, unencrypted form by processors. A lot of cloud service arrangements don't necessarily involve encryption. So I think that's going to be a challenge. And the other is use case 7, which deals with transfers where there's a shared business purpose. So it might be an intergroup arrangement where you're using a shared HR personnel resource, and the organisation in the recipient country has, again, unencrypted, clear access to personal data for a shared business purpose. And again, similarly, the guidance suggests that it's difficult to see what additional measures could be put in place to provide protection in those circumstances. So I think there are some real challenges, in summary, for organisations around meeting the Schrems requirements. As I started off the talk, the first step, I think, in terms of practical measures is to actually identify and map what data transfers you have. Think about your approach to conducting transfer risk assessments is that something that you can push on to the supplier, vendor, recipient in the third-party country? Is it something where you need to take legal advice, obtain a legal opinion on what the laws are in the relevant jurisdiction, and then think about what additional measures in terms of the encryption and pseudonymization you could put in place, but bear in mind that caveat around you having control of the keys or the mapping data and that not being shared with the relevant third party. So in the context of cloud, for example, don't rely necessarily on the encryption measure or the encryption keys being held by the recipient organization. And then contractually, and it's difficult in some circumstances, but thinking about negotiating additional contract terms with vendors and suppliers, both to cover, the recommendations in the guidance and also the organisational measures which are suggested in the guidance around recipients having appropriate internal policies and procedures in place relating to access by public authorities.
I think as a sort of a sidewind on that, it's probably worth mentioning the Ticketmaster penalty notice that was issued shortly before Christmas. And I think one of the key things that came out of the Ticketmaster penalty was that their argument was that they had in place contractual provisions that were obliging their counterparty to take adequate security measures in relation to data processing. And what the Information Commissioner's Office emphasised was that it's not enough just to paper over the situation, that there was no actual risk assessment and there was no real investigation of the technical and organisational steps that the other party to the contract would or would not take. So I think taking those two strands together, emphasising that papering over the situation is not in itself sufficient is a key takeaway. Okay, I'm going to go on to what I'll sort of laughingly call the lightning round now, which is to pick up some of the questions from the Q&A slot and see how far we get with giving some answers. So Andy, the first one. Once new SCCs are approved by the EU, doesn't the UK also have to approve them in order for us to use them? And I think the answer there is it depends how we're looking to use SCCs. Do you have any view on that?
I suspect if you're using them from a UK GDPR compliance perspective, there will need to be an approval from the UK as well as from the EU. Mm.
Absolutely, but in terms of let's take the concern that we've previously discussed, which is a transfer of data from an EU-based processor to a UK-based controller. What would be the sort of papering over, quote unquote, in that?
Okay, well that would be governed by EU GDPR, and therefore clauses approved from an EU perspective would be appropriate in those circumstances. Yeah,
so again, the answer here really does come back to that data mapping and understanding the direction of flow so that we can select the appropriate documentation. Next question. This one is an easy and horrible answer. Is there a list anywhere of accredited EU Article 27 representatives for UK companies so we can make sure we choose someone appropriate?
Not that I'm aware of, I think is the answer to that question. And it is difficult because we get asked this question a lot in terms of both EU and UK representatives in terms of who should we use. Is it a service actually we provide as a law firm? It's not currently a service that we provide, but other law firms do. And I think we've got various contacts so we can help people with individual requests in terms of those that we've seen offer those services. But to come back to the previous point, I think organisations do need to carry out appropriate due diligence, because a lot of the services I've seen are more sort of postbox type services, and my view is you should be very cautious about using that type of service.
Absolutely. This answer, I think, is slightly more convoluted, but here's the question. If you're a company...
You can answer it then, Malcolm.
Fair enough. If you're... Thank you so much. If you're a company who offers services to data subjects in the EU on a less regular scale, do you still need an Article 27 rep? That's the first part of the question. So I think that points us towards the kind of occasional processing elements in Article 27.
Yeah, so the exemption in Article 27 is very limited, because it only applies where the processing is occasional, does not include on a large scale processing of special category data or processing of data relating to criminal convictions and offences, and is unlikely to result in a risk to the rights and freedoms of individuals. So it is a quite limited exemption, and the European Data Protection Board guidance does make that point, I think, in terms of saying you should be cautious about relying on that exemption.
Yeah, absolutely. So just to really emphasize the point that occasional processing is one element of the test, and there is a very strong leaning against characterizing as occasional things that really are business as usual. Second part of the question, a bit easier. Do you need an Article 27 rep in each EU country you deal with, or just one?
No, just one is the answer, provided that one is one of those where the data subject is located. I think that's right.
Yeah, absolutely. Next question. We have an office in the Netherlands, but our head office and DPO are in the UK. Do we need to appoint an Article 27 rep or DPO in the Netherlands? So that's with a UK GDPR.
I'll let you start with that one, Malcolm, while I read it.
Well, I mean, always the legal answer.
Okay.
It depends, isn't it?
Okay. So they're likely to need to appoint a separate DPO. We might have to come back to that one. I think you could still have the UK-based DPO as the DPO for the establishment in the EU, but we need to look at that, I think.
Yeah,
so we'll pick that up in the Q&A follow-up.
Definitely. It's a much broader question than that, actually, because there are some of the new GDPR-like regimes that specifically address this question. And it's a question of sort of fitting them together. So, for example, the Dubai International Financial Centre, DIFC, data protection law that was enacted in July of last year, contemplates a DPO being appointed at organisational level and not being present in that jurisdiction in DIFC, but it imports specific requirements that the corporate DPO has a working knowledge of that DIFC regime. And that reflects sort of broader discussions among regulators about where DPO functions should sit in cross-border and international organizations. So there's quite a bit to that answer, which we will pick up.
I think there's a series of similar questions around whether public authorities or bodies need to appoint representatives, which the answer is no, but I think there's an interesting question where a public authority or body may be providing or offering goods or services, which has come up on the Q&A. And I do recall there is in the European Data Protection Board guidance a statement around that issue where effectively you have to consider on a case-by-case basis whether they qualify as a public authority or body for that particular activity. And I think the European Data Protection Board has said that they note that there may be cases where a public authority or body would be offering goods or services, but that those are likely to be limited.
Absolutely. But again, case-by-case analysis. We're in the last minute, so I'm going to pick an easy one to close. So we've been referring to UK GDPR. The question is that a reference to Data Protection Act 2018 as amended, or are we referring to other UK legislation? The answer there is that Data Protection Act 2018 did a couple of things. First of all, it essentially adopts the basic wording of GDPR and amends it to serve as the UK regime. So that stems from DPA 2018. The 2018 Act also implemented some UK-specific adjustments and derogations from GDPR. So it extended some of the provisions in relation to public sector processing. It provided for some carve-outs and derogations. And it also then implemented the Law Enforcement Directive, and together has components that make up UK GDPR. So 2018 Act is essentially our kind of source legislation for the UK GDPR regime. And a fairly useful document that flows from it is a thing called the Keeling Schedule that takes the text of GDPR and presents it as amended, as adjusted by Data Protection Act 2018. And that's accessible online by searching Keeling Schedule UK GDPR. Andy, anything to add?
No, nothing from me. Thank you all.
Brilliant. Well, thanks very much, everyone, for joining. We have the questions in our panel that we'll sort of go through after the event, and as I said, pick up any themes that emerge from them and send out a response together with a summary of the practical tips that have emerged from this session. But with that, thank you very much for taking the time to join us. Bye.
Thank you all.